let me drop here. So as I was saying, I have been talking about this book a few times now, never before as perceptive a reviewer as Christian. So I'm a bit intimidated, but also sure that this chat will be fun. Fun is a bit of an operative word here. I did have great fun writing this. Not in the modern kind of plain Oxford Dictionary definition of fun. Not in the Oxford Dictionary definition of fun as in source of amusement or pleasure. Actually, if you look closely, the etymology of the word fun is a bit rougher than that. Apparently in the 17th century, fun described cheating and infidelity. In the 19th century, it often meant crass, lacking sophistication. It was the leisure of the working class. And even today, according to Welsh sociologist Ben Fincham, fun has a bit of a transgressive or subversive element to it. So now, if you take this notion of fun, then I did have fun writing this book. At times, as I was writing it, I felt I was exposing and therefore betraying, cheating on a community of practitioners I was part of for almost 10 years. The book is intentionally unsophisticated. It's almost punk-like at times when it comes at least to the elaboration of international legal doctrine. You don't find a sophisticated elaboration of doctrine in the book. And I hope that the book is not transgressive, that's self-aggrandizing, but at least irritates the audience enough to provoke a bit of self-reflection from international dispute settlers. So what I thought that I would do in the next 20 minutes or so is to unpack this notion of fun by doing three things. First, to give you an idea of the general contents and general ideas of the book. Second, to explain quickly what I wanted to do with the book, what type of interventions I wanted to make. And if there is time to reflect a little bit on the reception the book got. The book has been out for a couple of years now. So was it fun for people to read this book as much fun it was for me to write it? So in a nutshell, the book is a novel, or perhaps a social legal novel, about the professional practices and interactions that take place inside international courts and tribunals. The long process that leads to the formation of international judgments sees the contributions of countless actors, some of whom are very visible, think judges, arbitrators, heads of delegation, and so on, and some of whom are much less visible, private attorneys, clerks, registry and secretariat lawyers, technical experts, court reporters, academic commentators, and the like. In other words, as we know by now, courts are not monolithic institutions that speak with a unified voice. There exists an entire community of judicial professionals who inhabit those institutions, who breathe life into their daily workings, and who incessantly shape the content of the decision that then we discuss, invoke, implement, interpret, apply in our disciplinary practice. So this book is a story about that community. It's a community that is still relatively understudied. There's more works appearing that study the community in various ways. It's understudied because we as international lawyers especially tend to appraise the activity of international courts based on their output, their judgments. The judgments are these highly symbolic, powerful artifacts. They are also the basic building blocks of our analysis, those that capture our imagination as scholars, those through which we understand and critique judicial activity. Now, don't get me wrong, a lot of scholars do many useful things with those building blocks. Some systematize jurisprudence, point to gaps and inconsistencies. Others look at how judgments strengthen or weaken the legitimacy of a given court. Yet others try to reverse engineer the ideological leanings of judges from the decisions they issue. But whatever the perspective, the point remains that the output of courts is the starting point. Now, the core idea behind the book is to flip this notion on its head. In this story, the judgment is not the starting point, but rather the end of the journey. A journey made up of conversations, practices, and struggles that involve a vast plurality of agents, who each from their own position leave a trace on the proceedings and the production of the final outcome. And so the core claim of the book, if there is one, is that the ways in which those agents, those professionals interact, cooperate, clash every day, is ultimately what makes international law. Not substantive rules, which have no inherent determinacy or life of their own. Not grandiose ideals, no cynicism, no Machiavellian machinations, just everyday practices and invisible frameworks in which they take place. So to illustrate this claim, the story imagines 5 international disputes in 5 international courts: the International Court of Justice, the European and Inter-American Court of Human Rights, the WTO appellate body, which is now dead, but I let you guess how long it takes to write a book, and an ideal typical investment tribunal. So in these 5 imagined settings, the story traces all the phases of international proceedings, from the moment the complainant sets up its legal team and decides to launch a dispute, to the final moment where the decision is issued to the parties and the public. At each step, we meet this multiplicity of protagonists. We meet zealous diplomats, ambitious attorneys, industrious bureaucrats, promising clerks, clever academics, and of course, a fair number of judges and arbitrators. Everyone has a part to play, an agenda to pursue, a constellation of beliefs and idiosyncrasies. And as the plot unfolds, hopefully, the threads become increasingly interwoven, slowly revealing the web of invisible ties that gives international law its mysterious force. Now, what did I want to do with this book? Now it's almost customary for authors to say, oh, let the book speak for itself. I don't want to comment on what I want to do. Call rubbish on that. I'm very happy to do that right now. I think that I wanted to do 3 main things. At the information or factual level, I wanted to shed a bit of light on the internal functioning of international courts and tribunals. You have so many works that focus on bits and pieces of the inner workings of these institutions, and yet so few that comprehensively explore what happens in this underbelly, in the soft tissue of the international judicial machinery. So at this level, and I think that in his review, Christian picked up on that, so I hope that this story will be of some practical use for litigators, for practitioners who might be interested in how the judicial sausage is made. This was one thing that I wanted to do. A second thing that I wanted to do at a more maybe theoretical level is I wanted to produce a certain rendering, certain imagery about international judicial reality. I wanted to elicit a certain imagination about them, certain reactions in the reader. By focusing on the everyday, the micro, the mundane, I wanted to depict international courts not as structured and orderly places, as they are typically portrayed, even in the social sciences, where certain things happen because of certain structural reasons, but messy laboratories, rather, where people assert and contest positions, pursue strategies, hesitate, stumble, sometimes heed to ideals, sometimes to cynicism, places where some initiative gain enough professional traction to become dominant, and other initiatives completely fail to do so. places where discarded possible are produced case after case, practice after practice, every day. So courts as messy places, messy laboratories, and this imagery, I think, allows me to avoid two opposite images that I really wanted to kind of avoid. On the one hand, well, the formalist rendering of international realities, the court as a impartial umpire that apportions right and wrongs according to a scientific process. I don't think that any international legal academic trusts this vision anymore, at least not fully. It's hard to find, at least where I come from, it's hard to find such a degree of formalism. But I also wanted to distance myself from a certain type of critique that basically says that international courts decide so and so because of political constraints, structural biases, the omnipresent forces of capitalism, of empire, of neocolonialism, etc. So these opposed images, the formalist image and the structural bias image, I think freeze reality in place. They're both deterministic. And I wanted, by focusing on the micro and the messy laboratory, to perhaps retrieve a bit of agency in the adjudicative process. This is a very internal story. The camera is firmly on the everyday lives of the community members with their shared outlook, the blind spots, the ingrained assumptions and dispositions. And sometimes this outlook, internal outlook from inside the courts, excludes reality, the outside forces at bay. It even blinds community members to what is really happening in the outside world. And the third thing that I wanted to do, it's probably the aspect that has been commented on the most, is to maybe challenge a little bit the style of international legal scholarship. So this novelesque, quasi-novelesque approach that I chose in the book makes the book a bit strange in the etymological sense of extraneous from Latin. So external when it comes to literary genres, academic literary genres. What I tried to do is to put my fictional protagonists and fictional disputes in as realistic a setting as possible, but still, despite the realism of the situation, both the characters and the matters they deal with are entirely fictional. The book alternates between moments of fiction, so vignettes that move the plot forward, and moments of more academic expositions. It's a back and forth, there's a bit of an accordion between the two. And these fictional and academic passages, well, I had to signpost them because the editors asked me to signpost them with little symbols. But they're meant to be read as a whole. Both the fictional and the more academic side of proceedings are supposed to both contribute to the type of story that I wanted to tell. Of course, writing in this style came with challenges, also came with opportunities. My decision to write in this style started out as a very practical question. The research that I conducted for the book comes from three main methods. One was, well, ethnographic participant observation. As James mentioned, I was part of the WTO Secretariat, and before that, I was practicing attorney for a few years. And I started looking around, listening, watching, and trying to understand how the exchanges that were going on around me were culturally and socially organized. So there's a big ethnographic part to the research. I conducted a series of interviews with sources from a variety of other international courts other than the WTO appellate body that share details with me on a confidential basis, on an anonymous basis. And then I tried to complete the picture by looking at the literature that was there. There was a part of desk research, and I had to read, for example, the memoirs of retired judges and former clerks or registered officials to try and get more information. Now, this massive information created a problem. The problem was, well, confidentiality. A lot of what happened behind the closed doors of international courts should not be revealed to the public. And my sources, my interviewees in particular, wanted to, were adamant about being not identifiable. We had to sign agreements to this effect. So I had these massive information that was interesting, but then I didn't know how to render it, how to put it into an account. So one choice would have been, okay, let's do like Yves Deslay and Brian Goff did in Dealing in Virtue. Let's assign each interviewee a number. So to have something like interviewee 23 said this and that, interview 11 retorted that. I found that scientifically rigorous, a little clumsy for the type of story that I wanted to write. So I kept reading to see how other people had dealt with similar problem. I saw that Bruno Latour, in his ethnography of the French Conseil d'Etat, had fictionalized the names of actors, of agents. He called them John, Mary, etc., to preserve their anonymity. But even that was not enough. Because, well, the pool of interviewees, the pool of actors that I was interviewing and trying to describe was very small. In the end, the international judicial community is made of a few hundred people. So if I say, well, John is the director of the secretariat of the appellate body, well, you can call him John, but you would know who that was. So what I decided eventually to do was to fictionalize the whole thing. So to create these fictional characters that are archetypal, so they want to kind of symbolize what these real interviews, these real actors stand for. Hopefully are endowed with realistic personalities, but they are more of a mix. And sometimes there's a bit of literary freedom in shaping these characters. I found that these were the only way I could present this information while maintaining confidentiality and the anonymity of my sources. So this was the very practical hurdle that I had to overcome when I chose this writing style. And then, of course, as I was writing, I started having fun doing that. And so, as the French would say, je me suis laissé emporter. I kind of let it take me. And so, well, one thing led to another. Hopefully, fortunately, so this book is taken from my doctoral thesis. My doctoral supervisor at the time was approving of these kind of unconventional methods. Pressed me to go on with it, and so there you have it. So this is what the book is, what it seeks to do. Now it's been out for a couple of years, as I was saying. So for the next final 5 minutes that I have, maybe to take stock of the reactions it elicited. I don't want to prejudge anything that Christian must say in a moment. So, but I had fun imagining the reaction of two main groups here. One was, well, academic readers. How would the academic community would perceive this book? Would they find it persuasive, informative? Would it dismiss it as a curiosity? Would they not engage with it at all? In the end, every author, you don't care as an author if your book is well received or poorly received, you want it to be received in some way, right? And so that was kind of my first preoccupation. And the second preoccupation, of course, was, well, how will practitioners react to the book, if at all? Will I burn bridges with my former friends and colleagues? Will they be offended, amused, or something in between? So when it comes to the academic community, I think, well, there has been quite a bit of engagement that makes me very, very happy. Different reviewers picked up on different aspects, these different interventions. Most focus on the style, others on the substance of the story that I wanted to tell. I feel nervous about, still to this day, about having written a book like this at a relatively early stage in my scholarly career, because in a sense, the book does not advance scientific knowledge much. There's still a gaping hole in the middle of this narrative. An eclipse, kind of. You cannot look directly into, that is, well, the final determinants of judicial decisions. So if you're reading the book to finally get why international courts and tribunals decide the way they do, you won't find that answer. So the center remains very indeterminate. All that I can do is to provide you a lot of information around that central whole and hopefully let you insert the final tile. So in a sense, I'm not telling anything new. And some of the critics of the book say, well, the ideas around this book may be nicely packaged in a novel style, but these are old ideas. If you're a realist, you're a postmodern or a critical scholar, I mean, we've read this several times before. All the way since, for example, Duncan Kennedy wrote about the phenomenology of adjudication. There's nothing particularly new here. So this is one of the things that make me pause. Also, there are challenges in trying to push this type of perspective also for professional reasons. Recently, I had to submit my scholarship to a scientific committee for career-related reasons, and two members of the committee in their report wrote that a book like this and the scholarship that I produced around it are not international law. They do not, and I quote them not to disparage them, but I found the quote interesting, they do not address the real questions of international. This is a lot of fluff, probably nicely packaged fluff, but this does not advance, once again, knowledge in substance, the procedure, or the practice of international law. And so that made me think, once again, writing something like this, if you're still trying to advance in your career, has a measure of risk. So for those of you who are in their junior stages of career, this might be something to keep in mind. When it comes to practitioners, it was interesting. So for quite a bit of time, there was complete radio silence on the part of my former colleagues at the WTO. Those of my colleagues that were personal friends said, yeah, I read the book and it's fun. But all others had zero comments, radio silent from anybody in other international courts and tribunals. So I started to say, okay, maybe this simply is not a piece of scholarship that appeals to anyone involved in practice. And then a few months ago, though, I had the chance to have an informal chat with a former ICJ judge, and to my great delight, he said that he had read the book and he and his colleagues were commenting on it, and they were finding a lot of interesting gossip about who did what in what instance, and tried to at least piece together who my informants might have been on a number of things. So at least some practitioners are reading this. I don't know what they will make of it. This is a very distant work from mainstream legal scholarship that international judicial practitioners tend to rely on. But hopefully, they, at least for some, these might become a bit of a guilty pleasure that they read, but they cannot really talk. So I'm looking at the clock, and I want to stop. I look forward to the discussion. Just to say, and especially for those who are thinking about writing books, don't forget the fun. Whatever you do, try to have fun in writing your scholarship. Again, not fun only as a source of pleasure. Those of you who are doing PhD thesis will know that, well, pleasure is not necessarily the best descriptor there, but fun in the sense of these kind of a bit of transgression, these things that fires you up a little bit. That's what kept me going throughout the writing of the book. And in the immortal words of the Joker and Jack Nicholson impersonation back in the 80s, fun is a tremendously serious business. So, well, thank you, and I look forward to the chat.
Okay, well, thanks, Tommaso. Let's do the chat while we're standing here. I'm glad that we don't now have to hand over the microphone between comment and response. That's helpful. So first of all, thanks for the introduction, and perhaps more fundamentally, thanks for writing this book. I have a few questions that I want to put to you to pursue what you've been saying in introducing it, and perhaps also in setting the stage for the discussion that we'll have. But I'll preface this by saying that I really enjoyed it. It's really a great book, and I think whether it was fun as serious business that kept you going, or whether it was some sort of attempt at rocking the boat or doing things differently, whatever your motivation, I think the outcome, well, the output, I think is worth our time. And I'll say this for three reasons to just perhaps recapitulate things that you have said, that for those who are new now to this book and haven't read it, I mean, I've had the benefit of reading it, it may not have been so obvious. So I think the style is truly, I think, unusual. I think you've described it, sort of intermixing, interspersing fictional accounts with let's say, factual provision of information. And I think that is, well, I think that we can discuss whether that has limits, but I think it's a very helpful break with legal writing traditions. You call it, I think, genre bending in your preface, and perhaps it bends genres. But of course, the genre we're usually exposed to in legal writing, academic legal writing, is just so dreadfully boring that I think any attempt to bend it a bit is good. And we can try to be eloquent within the limits of the genre, but the genre's limits are so relatively constraining. So I thought any attempt to play with that, including playfully, was worth our time, and I think worth the support. So, but I think it's, and this is my second point that I want to make in opening this, it's not just about the style, and I think there's a risk of reducing it, and maybe some of the reactions you've described fall prey to that risk, that this is very unusually written, and then everything has to focus on that. I do think there is an enormous amount of information in this, whether that's research or academia or provision of knowledge or manual. I would dare everybody to say, read this book and tell me you've not learned anything new, including your assessors that you've described from the academic committees. We could ask them about, do they really know how notes play a different role in the judgment production process in the different institutions? Maybe they think this is not really new, anything in there, but I think, would they really know what the role of assessors is in the various courts and tribunals? Would they really know what the role of internal deliberation is in the various investment tribunals versus ICJ versus IACHR, Inter-American Court of Human Rights? And it seems to me that most who say that there's nothing new in this or nothing academically new would fail the test in the relatively early stages of the questioning. It's sort of, do you really know everything that's in it? I've spent a lot of time on working in courts and tribunals. I learned an enormous a lot. Now, learning something new isn't the same as academic writing, and so I'm not saying that these people get it all wrong, but I think there's an enormous amount of information in it, in the underbelly of courts, as I think you said it. Third point, and this is the final point I want to make in opening, is I think it has an egalitarian streak. I mean, you've described how you wanted to avoid the two ends of the spectrum, reification and formalism, and just stand looking in awe at these great courts who give us the law, and the sort of the cheap criticism that it's all just politics anyway. And I think that's fine. But I think there's also an interesting egalitarian streak in the protagonists that you choose, that were led through this process or into the underbelly, not following Judge Miller and arbitrator Smith, but that it's the judges' clerks and the small number, sort of not the big law firm rainmakers, but the sort of the small starting junior lawyers who are your protagonists. And I thought that had an egalitarian trend that had shone a spotlight on some of the actors that are not even in accounts that look at the personalities that are not often in the limelight, and which perhaps in the mundane micro practices that you dissect do play a lot of a bigger role than we account for in the writing. So these are just three sort of, if you want, immediate reactions prompted by what you have said. I think I'll conclude those opening comments, and then I get to the questions by saying, if we were now in a TV book show, I would all say, buy this book. Buy this book. All right, but let me ask, you're not here to hear me say, buy this book. Maybe Tommaso is here to hear me say that, but I think let me start the conversation part of this. And I think we can do it in a spirit, I mean, sort of I think, candor and frankness, because let's see whether we can entice a bit more about the book writing process. So I'm starting with the style point, which I find the most, in some ways, bold, interesting, intriguing bit. Not the only bit that's worth in this book, but the most obvious, unusual feature. So I'm just curious. You said you did this to keep going, to see the fun part of it, but did this come to you as sort of on a walk along the Lake Geneva? Did you think, I want to write differently? Was it something that materialized halfway through your PhD? Did you feel sort of somewhat overwhelmed by that decision? Or, I mean, was it sort of a momentous decision or something that grew within you over time? Because that, I mean, I would imagine that requires a bit of boldness and a bit of reflection and sort of second guessing of whether you're doing the right thing in going for the genre bending take.
It was not a revelation. It was a slow process. And as you said, like he came with almost a daily identity crisis. What am I doing here? As I mentioned earlier, so I had a number of methodological challenges to overcome, confidentiality. So that was the kind of the initial prompter. How do I do this? And then I started to experiment with different narrative formats. I had collected the information that I needed to write a book. And well, first, once again, I tried to proceed. I tried to take inspiration from how others people had done it. So that's as a junior researcher, I think that the first thing you do is how have other people. And so the first book that I turned to was dealing with virtue, and I saw that, well, Tesla and Gard had 300 in it, so I only had 30, 35, so the samples were very different. But if you go through that book, which is a massive book for those who haven't read it, they will see, well, a lot of excerpts, like block quotes from interviews, which are numbered. I found that great, but also a bit heavy, like almost as if the narrative was almost, the methodology was weighing down on the narrative. And then I looked at Latour, I looked at another number of authors. I looked at David Kennedy's, the name of the book, but the Rites of Spring, so which is a kind of novelesque autoethnography by David Kennedy. So I tried first to look at how others people did it. I was not fully satisfied, and then at that point, I remember that I was due to produce a full outline of the thesis for my doctoral supervisor. And as I was writing that outline, I said, oh, how do I start the book? Let's imagine this character, Sophie, which is one of the characters, who is one of the protagonists of the book, as she listens to the delivery of an ICJ judgment. Why is that not an opening? And why don't I tell the rest of the story as a series of flashbacks? And I say, hey, I've just created a character. I've created Sophie. Why don't I create other characters that might also populate this world that I'm trying to describe? And as I sent this outline, I was like, oh my gosh, I hope it works. My thesis supervisor said, well, this is fantastic, go on. So that's the moment where I got the courage at least to try and make the leap. How then I did it, it was very difficult. I don't think, so there are a number of academic works, including in law and international law, that kind of double with fiction, but I don't think that I have found exactly the type of narrative that I tried to convey in the book. So how do you do that? Well, you just do and hope and pray it works. And I had constant identity crisis. Sometimes I would read back a chapter and say, no one in their right mind will find this even remotely persuasive. Also because, let's face it, I'm not a novelist, I'm not a writer. So I come from a certain disciplinary training in ways of writing, and forcing that was almost doing force on myself. But yeah, so it took forever to write this book.
Yeah. Well, I mean, you could also say maybe one thing that's hidden in that is that the minute you go for something that's not the ordinary style, you need to spend actually time on reflecting how you present it, not just how you, if you want, what the sequence of your argumentative steps are, but how you present it. And I think then sometimes in law schools, we tend to forget that aspect of legal writing, that it seems to be all about solving the issue and then it writes itself, because we give protocols of writing or protocols of legal reasoning that are then followed and applied, whether that's a plan binaire in France or Gutachtenspiel in Germany, or an essay standard form in the UK or the US. So I think, I mean, investing time in reflecting on the presentation of an argument, I think is something that probably lawyers don't do enough. I mean, not probably practicing lawyers do in court, but academic writers probably don't do enough. Okay, but let me then, okay, so I think the confidentiality point, maybe let me pick up on that. That seems pretty, a pretty obvious concern. So you know these people, they're maybe your friends, they're your close colleagues, and all of a sudden you write a not a tell-all story, but a sort of a tell something story. So did they all just, I mean, did you ask them before? Okay, all right, so then nobody, I mean, they may have still found themselves shocked when reading it, but in principle, they knew what to expect.
So when it came to the interviews, every interview was preceded by a contract agreement with the interviewee. I would be able to tell whatever information they shared with me on condition of strict anonymity, that is, not being directly or indirectly identifiable. We agreed on no off the records, and actually quite a few. And one of the also provisions of the agreement was that then they would have the opportunity to look at the manuscript, of the entire manuscript, and see if anything made them identifiable. Some of them have asked to look at the manuscript. None of them have objected. The vast majority were super skittish when I interviewed them, but then didn't even ask and say, I trust you, it's fine. And also interestingly, depending on the court of reference, people were a lot more open or a lot less open. So the Inter-American court people, I mean, only interviewed 2 or 3, were super open, say, yeah, you can put in my name. I don't care. I wrote these decisions for the judges. You can put it.
And presumably the ICJ people were the most cagey.
Yes, absolutely. Absolutely.
So,
The
yeah.
ICJ, but also the European Court of Human Rights. Whenever I interviewed a junior officer in the secretariat, in the registry, they said, I need to check with my leader, like leading lawyer first. So different styles in different places.
One final point on this sort of the style. Since you mentioned Desalé and Garth, I remember hearing that everybody admires their work, but they scorched the earth. Nobody will ever do interviews again in the arbitration world because they saw what Desalé and Garth did with it, and even when they anonymized the sort of the dealing and virtue business, people felt exposed.
Mm-hmm.
Do you have a sense that this may be a one-off? You've done it, perhaps successfully navigated the confidentiality issues with your interviewees, but ruined the opportunities for future Soaves to write books like this?
No, hopefully not. I think that the majority of the information was collected either through ethnography, so keeping my eyes and ears open as to what was around me, and using gossip. So gossip, we discussed it over coffee before this session. Gossip, if you want to do ethnographic work, is an incredible source of information. Not because of the content of the gossip that you need to verify, but because it tells you what a certain social group is interested in, what they find relevant. So gossip was a central part of it. And then there was a lot of, so in order to kind of mitigate the confidentiality problem, I also looked at a lot of sources that were publicly available, for example, of judges, registered officials reflecting, especially retired people. And I referred a lot to those. There's a lot of footnotes going to that literature. Let's say that interviews and ethnographic fieldwork allow me to read those sources against themselves. So very often these memoirs are very self-congratulatory, and we did it. When you know how things really work in practice, you can read between the lines and kind of pick on the interesting bits. Those. I don't know if that burns bridges. It might have burned my bridges, but hopefully not those of future authors wanting to do something similar.
I have one more question, which takes us away from the style and to sort of, if you want, the macro level, and it goes to the title. So, I mean, as you know, I enjoyed reading it, as people in the audience will have heard. I'm very keen for everybody to read the book. But one thing that puzzles me is the title, and I think you avoid self-aggrandizement, and I think, but the everyday makers of international law, that's the one thing that gives me pause. I mean, this is an exciting story of what sausage or underbelly or whatever, machine room, whichever metaphor you want to use. But aren't you, by looking at how law is made in the courts, or judgments are made in the courts, aren't you confirming the major problem of international law more generally, that we completely obsessed about courts which deal with, I don't know, 2% of all the disputes that matter, 2% of all the disputes that matter, and 98% are dealt with elsewhere. And now here we have an interesting genre-bending take, or here we have a novel method of looking at it, and it reinforces this biggest problem of international law education that all we talk about is courts. Slightly exaggerating, but I think only slightly, because I do think it's a concern. And you have the same with empirical studies. You've got a rise of sort of the application of not a new method, but a new application of a method to international law. And what do we get? Citation references, or sort of use of lots of machine, lots of computer technology. And what do we have? Even more on courts. And don't we have more than enough on courts already? So shouldn't you have written a book on the everyday makers of international law in NGOs, in domestic government, where international law isn't already seen already?
You're absolutely right, Christian. So a little anecdote. The one time I spoke to, the one time I was speaking to Gary Simpson, and I was telling him, I'm writing this book about international courts, and his first reaction is to say, who still writes about international courts? It's so boring. So I think that I got that, and indeed, as part of this community, international judicial community, I tried to resist the doxa of that community, those things that are taken for granted, and try to problematize the doxa, but I was still holding my doxa beliefs. One of them being that adjudication is very central to the governance of the world, and probably, and I don't think it is. It's also a matter of access to information. Once again, the idea behind this book emerged from being part of a certain bubble, and to describe that bubble. So that's the type of access that I had. But you're absolutely right. This falls into the trap of perpetuating this obsession, disciplinary obsession that we have for international courts and tribunals, that I don't think is a healthy one. I was reading recently, there's a edited book now by Jan Johnstone and Stephen Ratner arguing outside the courtroom, and it's quite a good book, because it kind of problematizes this notion that we are so obsessed with courts that that's all we see.
But I mean, it starts with justifying that there should be room for talking about international law outside the courtroom. I mean, all international law talk happens. I mean, not all, but 99% happens outside the courtroom. So I think the fact that they felt the need to justify to me may suggest that they're not really liberating us, but reinforcing the problem yet again. Anyway, that's all I wanted to ask. James, I'm looking to you. Do you want to? I think we should move to a discussion and open it up, whether to people online or in the room. And I think people have put their hands up already. Do you want to moderate it? Do you want me to do it? I'm easy. I think I can withdraw. I've had my 10 minutes of glory. I'll withdraw to the seat again, but not without having said. Thank you, Tommaso.
Thank you, Christian.
And let me then just encourage those online. If you have any questions, please just pop them in the chat. For now, let's open up. So I saw your hand first of all, and then I'll come.
Yeah, I just want to say, I didn't know about your book, but I'm going to get it and I'm going to read it, because I'm at the beginning of my PhD. I'm in my second month, actually.
Oh, wow.
But I've had similar reasons to starting my own research to yours, evading the rigorous formalism and the criticism as international law as mere politics. I wanted to avoid them both, but I also thought that we needed a foundational theory of approaching international law in this sort of way. So what I'm doing is actually trying to conceptualize international law as culture.
Fantastic.
So there's a lot to say. I'm really looking forward to the rest of the discussion, but I actually have to step out for like 5 minutes to meet my supervisor, but I will be back. Yeah, I will be back. So I think it's great. Yeah.
Thank you.
And I actually have lots of questions too, especially in terms of narrowing down. I'll be back.
Yes.
Yes. Sorry.
Okay, let's continue this discussion.
Yeah, I'll be back.
Good luck.
Thank you. Yeah, meet him.
First, it's great to meet you finally. As you know, I have read the book. I think it's tremendous. I found it incredibly useful. But in that, I've also received compliments on a piece I wrote, which draws sections. So I thank you for that as well.
Yeah, thank you.
I have two questions, and they really are just genuine questions. You described a black hole at the heart of your portrayal of the sausage machine, which I think Makes sense, right? People do this. I would push you a little bit. What would you say? Okay, this is fantastic. What does it mean for how decisions are actually made? What does drive this?
Yeah.
In your view, strategic considerations, principal considerations, doctrine. What's sort of the next? You know there's a black hole. What's in there? In your, what do you think? What's your impression? And the second question is much more tailored, much more specific. Let's say. I'm working on the WTO, the appellate body. I find it fascinating, and you tell a very rich account of happenings in Geneva over the past decade, which is wonderful. What next? Yeah. So, and I say that more than the question: what's the policy prescription, if you like? What behaviours do you think would be helpful or possible, given where that institution nowadays or isn't? If that is the right phrase. What's the action that might flow from your take from this stuff?
Absolutely. So let me start from the second question. So I must say that I don't have precise prescription or answers to either of the two questions. But when it comes to the WTO, especially in light of the results of the US election, I don't think that the WTO judiciary will go back anytime soon to the way it was before. I'm not only talking about a revived appellate body, I think that's science fiction, but also that kind of style, judicial style, where both panels and the appellate body treated themselves as the World Trade Court, that they operated like an international court. That was precisely one of the points of discontent of the United States. So the United States made it sound like they didn't like the overreach and they didn't like the interpretations of anti-dumping duties and zeroing. So there were, if you read the report, there are very concrete lawyerly reasons. I think that what is in the back is the discontent with the notion that these bureaucrats in Geneva and the educators were walking like a court. They didn't like that. So I think that under these push, I don't think that we will go back to a judicial system, a trade court that behaves like a trade court. What I will see is probably a more hybrid kind of system or panel. So there will be panels still producing legal reasoning, and they still are, but then more as a inducement for the parties to settle in the shadow of this legal reasoning. That is my impression. Of course, especially since the book came out, I'm not in close contact with the WTO crew. One thing that is quite interesting is to look at what the MPIA is doing. So the arbitrators, the multi-party arbitrators that were set up as a patch for the missing appellate body. I think that for those who want to research that, there's a lot to be gleaned from the few awards that have appeared in terms of how they want to distance themselves from past practice, how want they follow up, keep following past practice, if you know who the arbitrators are, and how they position themselves. Look at these micro details for instance. I think that at the more sociological level, what is happening at WTO will be very interesting to watch, because once again, there's a community, a very tight community of practitioners who have been there for at least 30 years since the start of the WTO. Many of them there. And they're trying desperately, scrambling to reinvent themselves and see how they position themselves in evolving times. And sometimes you see things that are almost comical, like complete U-turns in how they interact publicly. You will see, I think it will be very interesting also to study from an academic standpoint how these communities presents itself to the world. So instead of my international law professor in the United States at some point told me that he renamed his course from WTO regional trade agreements to US foreign trade policy, something like that. So that might be a very US based thing to do, but once again, also how is this community kind of reshaping itself in the way it presents itself academically out there? So not a very precise answer, but when it comes to the black hole at the center of the sausage factory, There's, yeah, it's a, like, let's see, I will think about how that sounds in it later. How do judges and courts reach decision? There's an increasing set of studies, of behavioral studies, some of which are very interesting and telling about how judges reason, how judges reason as a group, how judges reason as part of an institution. So there's a rich literature there. And I think you could find some answers. In my experience, I'm a little suspicious of literature that tries to prove too much. So if I give you the ingredients, no matter like the cognitive ingredient, the social ingredients, the political ingredients, shape and produce a result. Sometimes these cognitive studies tend to overplay and overdetermine how a certain judicial decision is made, and they do so for two reasons. The first is that adjudication is a collective process. Not only you have more than one judge assigned to a case typically, but then you have a host of different actors that exert their influence. The European Court of Human Rights, Registry, the WTO Secretariat, for example, are very powerful actors in this process. And there too, you have several legal officers assigned to the case. You have a lot of different hesitations, little like communications. So to only focus on the minds of judges like kind of misses the picture. There's a lot of contingency. Let me give you an example. So I was working at some point in a case, and I knew that I wanted to suggest my judges to move in a certain direction. But then I completely lacked an authority. I said, oh, is this an act of interpretation of my part? I'm just a legal assistant. Not possibly say, well, this is my idea, so apply it. So one of my interns at the time came up and said, yeah, have you read these report from the 90s? There is a little bit there that might help. And I look at this panel report, there's a sentence that absolutely persuasive. I say, okay, let me put that as part of my note, my issues paper to the judges. The judges like the quote. The quote ended up being almost the cornerstone of that bit of the appellate body's reason. There was serendipitous. Had that intern not done her job properly, I would never found out. I would never put out in that quote into the issues paper. The judge will have never known about it. Maybe, I don't know, but probably not. And it would have ended up in the report. So there's a lot of contingency in adjudication. And I know that this is not very satisfactory because you want to think that these courts like reason their way in a way that the missing tiles can somehow be identified. However, if we throw enough energy at it, we will fill the gap. I don't know that that's a gap that we feel. There's a lot of contingency, almost randomness at times.
Just very, very briefly, I perhaps phrased the question correctly. What I should have said is, what can we say about the black hole? I think that you've answered perfectly. So,
Okay, great. Well, thank you.
So we have one question online, but let's a couple more questions in the room. But I think Tony, you were next, and then Joseph. I think Joseph.
Sure. I'll go then. Thank you very much for both the talk and the book, which is certainly fun. And I suppose I have two questions, sort of, unfortunately, they're perhaps towards the method, the approach. And you sort of call it a quasi-novel. And I was sort of thinking, it's not perhaps something that international lawyers look at very often, but there's scholars that work in law and literature and try and draw truths from literature and novels and literary works to understand law, where law is represented in literature. And in a sense, you've done the reverse, where you're a legal academic, trying to convey truths about the sort of ethnographic research and social research into functioning of legal institutions through literature. I suppose the first question is, what do you think about sort of the utility of literature and non-fiction as a way of actually conveying truths, and whether it's a better vehicle for conveying truths than certain standard ways of legal academic writing. And secondly, in a sense, you say it's a quasi-novel. Large parts of it are not a novel, and you have standard citations, and it's part of the way you present it is almost that you have to defend the novel aspect and say that there is real research here and so on. In a sense, do you think you're being too conservative and that you should actually have gone further and written it as a full novel?
Second question first. I was too conservative. I should have probably pushed a little further. It's true. So one of the regrets that I have with the book is that it didn't go far enough. At the same time, you have to put yourself in the position. So positioning is also very important. You're a PhD researcher that wants to publish the first book and is already pushing the envelope a little bit. If I had gone full novel, I don't think, to be frank. So I think that again, the positionality of the author and what the author needs to do, we cannot discount that in academia. We always in academia tend to kind of sideline the notion that whatever you do is pure and it reflects an authorial intent. It also reflects the position. That should be very, very transparent about it. Who knows? Maybe in the future I will drop the quasi and try to write a proper novel, which terrifies me because at that point, I don't know. This is a good novel. It's probably dreadfully boring for a literature reader and probably too sloppy for a formalist academic reader. So let's see. On the role of fiction in conveying truth, absolutely. So one of the things that I did as I was trying to decide how to write this, but also later on, was to look at academics, thinking about the role of fiction, pictocritical studies, and other strands of literature. I think that fiction can convey truth very powerfully at times. And I was going back to some of my readings from more serious to less, like more lighter novels. When I started writing this, I had just finished Little England by Jonathan Coe, which is a book that I love. It's probably not a super serious or hefty book, and probably like things over the politics of Brexit a little superficially. Yet, by reading that, I felt that I understood a little bit. Told me something as a non-British about the social phenomena and the type of feeling that might have animated Brexit. So when I think back on the whole Brexit ordeal, I always think back to that novel. So that book, I don't know if it was meant to teach people something, but it certainly taught me something about the politics and feelings that were there. So yeah, I do think that fiction serves a very powerful function there, and I hope to see a bit more of that also in legal studies. Yes,
Hi, Tommaso. I haven't read the book. I have read Kristen's review of it now, and I would like to read it, having heard. Can I ask you, this metaphor of the sausage factory going up? Now, usually when the cameras go into the sausage factory, you see what they've recorded, you never want to eat sausages again, right? This is usually the point of shedding light on what's happening inside. Now, I'm not getting the feeling that, the point of your book is to put people off eating sausages or to change the way sausages are made or anything of that sort. So, could I ask you what the argument of the book is, if there is one? Because you've spoken about, being persuasive or, having, and Christian has mentioned a lot of, there's a lot of information here. That's fine. But is there an argument beyond this can be done? We can engage, is there something beyond, or is it just jeu d'esprit? In the sense that, and I also have to say, having had hybrid experiences as yours between academia international adjudication. That in hearing you, and again, I have to read the book in fun, but in hearing, I'm getting the impression there is a certain validation here of the self-perception that I know practitioners have, in the sense that if you know, in that community, it's very prevalent to, you know, nominally but highly formalist understanding of the law, or have complete contempt and no consideration whatsoever of anybody outside of that community, and ultimately see themselves as the real makers of the system, as a system that is driven by the individual agencies of the people. So I am, you know, it's just a complete fantasy, of course. They are seeing themselves as free from all the constraints of the real world, etc. So is there not, ultimately, is the argument of your book not a validation of that self-perception?
Great, thanks. Fantastic questions. The argument, about cynicism. So this is not a cynical book. It's not meant to be cynical as in say, well, once you look at how judgments are made, you lose. It was not meant to for the reader to lose faith in the business of international adjudication. I didn't come in with that intention. It's an enterprise that I still feel a sense of belonging to in whatever capacity, and I don't think that it should be necessarily kind of brought down its pedestal. What I try to do is to retextualize that reality by looking completely disregarding the procedure, the norms, the official powers, and looking at it as through the lens. If you want a theory, the closest thing that you will find to a theory in this book is practice theory. So through everyday practices, how they produce meanings, how they contest meanings, how they let legal and judicial meanings evolve. I didn't reveal, so if you read the book, you will not find any dirty secrets. You will find, there's no revelation. It's like, you know, when WikiLeaks came out and everybody jumped on the leaks hoping to find some.
There's no darkness.
I'm sorry?
There's no darkness.
No, there is. So the darkness is, if you will, to shed light on sometimes how this community thinks of itself as the central makers of international law. So there's a lot of discussion, for example, how every protagonist in the book takes certain legal positions or engages in practice and communications, always with a dual agenda in mind. On the one hand, to advance a certain opinion, and on the other, to consolidate their position inside that bubble. So very reminiscent of the logical field, of producing logical field. So the book never separates what these protagonists do in terms of what they say about the law and how they want to position themselves in order to aggrandize, increase their capital and their social standing vis-a-vis their peers. So if there is something that the book does and pokes a little bit of fun, is precisely at some of the things that you've just described. A close community that thinks that they are immune from certain types of social dynamic, from these external forces, that they find themselves as the real and sole makers of international law. Whereas, as in any professional community, there's also a lot of instances of hidden competition and cooperation in the professional field. There is careerism. There's a lot of, like, you have quite a few protagonists that act out of careerism more than anything else. Others that follow some ideals. I try to diversify these motivations. But besides that might be seen as poking a little bit of fun of this community. You're right. So there's no intent to depict the system as something that holds some dirty secrets that need to be revealed. It's more to retextualize this community and describe its inner dynamics to see how the dynamics themselves are. Is there an argument for a book? Maybe not. So there's no normative argument in the traditional sense. It's just that I wanted to take an object of much academic scrutiny, that is international education. We talked about it almost an object of obsession, and maybe you reveal it for this actually small professional business. It is. So this is a small community of people that take very important decisions, but in small and mundane ways very often. So is that enough to sustain a whole book? I don't know. For the editors it was, but yeah, I got that type of reaction quite a few times, and I think it's a very legitimate one. I don't know if I answered the question.
Of course I have.
So yeah, we have one question online from Thanks Putra, asking you about the challenges that you've faced in piercing the veil of secrecy that shrouds international. Maybe you can just one answer.
Yeah, sure. Yeah, no, I do see it on the chat. Hi Benny, good to see you. Benny is pursuing his doctoral studies at Central European University, very active member of our doctoral community. Piercing the veil of secrecy. Once again, the question that one of the problems that you have as a researcher when you try to do ethnographic fieldwork, participant observation is access. Back in the day, when ethnography first arose, problems of access were, well, the ability to travel to a far exotic, quote unquote, land and speak the local language. Nowadays, if you do an ethnography of an institution that is geographically close, well, your problem is access. So, you need to be accepted as a participant observer by your community. And sometimes the participation part and the observation part can be a bit in friction with one another. Because if you present yourself as a pure observer, well, then the people surrounding you might be tempted to present to you the version of reality that they think you want to see, or they want you to see. So if you introduce yourself as I'm doing ethnographic fieldwork, well, that's not often the best strategy. Suppose that you apply for an internship at an international court and say, yeah, I'm there to do ethnographic fieldwork. I'm not sure that your CV will be the first that is then selected for the position. But if you're only a participant, so if you participate in the community and try to absorb its logics and you reveal its secrets at some point by participating, you almost become incapable of seeing the community from the outside. The more embedded you are in the community, the harder it is to kind of take a step back. It's like David Foster Wallace told that story of two fish swimming and meeting a third fish who asked them, "Hey guys, how's the water?" Answer, "Well, what is water?" So if you're too deep in the water, you stop seeing the frames in which you're operating. So yeah, it was complicated to run that exercise also because I was not there, I was not at the WTO for a short stint doing ethnography. I was trying to make a career in international trade law. So yeah, what is shrouded in secrecy and the way you have access to it creates access problems. Also, do not discount, since you're also starting your research, that this type of work takes a lot of time to conduct. Ethnographic fieldwork, I think, is a fantastic research method that I'm happy to see is gaining traction also in international legal studies. But as a practical challenge, spend time in institutions and contexts, and maybe having more than one round of ethnographic fieldwork takes a tremendous amount of time. So depending on how much time you have to complete your thesis or write your book or write your next article, well, you have to factor that in.
First of all, thank you so much for your insightful introduction.
So would you mind just speaking up so that maybe the microphones can.
First of all, thank you so much for insightful introduction. So I do have one question for you. When you decide to write this book, so do you think some information in this book, such as providing the sensitive issues behind the dispute settlement process or the inner working of international court and tribunal, make the readers have learned negative things about that process, and also may impact the reputation or the image of international court and tribunal, and also the work of legal legal professionals, like because I'm a legal practitioner and I want to protect the image of court of the arbitral tribunals.
Yeah, well, that's a great question. I think it kind of relates to what was asked before. So what image emerges from the book? My intent was never to portray a negative image. There's the entire chapter 6 of the book basically breaks the narrative and starts and stops and considers what is the narrative doing. So let me take a break from the story and use this chapter to reflect on what the story is revealing. Does it shatter the mythical aura of international adjudication? I don't think it will, to be honest. I wish that it painted, like, I would be happy if you painted a slightly more realistic picture and maybe a little less mythical aura about these institutions to allow the reader to see what happens in them, to reveal how small sometimes things really are. Does that diminish the legitimacy or the image of international courts? It depends on how you approach it. I think it could, in the long term, strengthen this aura. Let me once again give you an example from my experience at the WTO. When the United States opened fire on the appellate body, I heard a number of academics, especially from the US, saying, well, the appellate body is in the hands of this cabal of European Union lawyers that are biased in favor of the EU and against the United States. You don't see it, but it's there. There's secret kind of allegiance between the WTO and the living. Maybe I didn't see that. Maybe it was there. That secret cabal was there, and nobody invited me to the party. But being inside the WTO, I can tell you, was there? Of course, there's micro practices by which certain modes of thinking kind of circulate and kind of are adopted, circulate across communities. Certainly, some lawyers who are experts in new law enter then the secretariat or became judges. So there's certain kind of types of practices and communications that can be transferred. But was that secret kind of Area 51 type of cabal? I didn't see that. So sometimes by revealing how small things can actually are, you actually kind of remove ammunition from the hands of those who want to attack the system. Much like with Area 51, I do cite Area 51 at some point in the book. The moment the Obama administration lifted the secrecy around Area 51, people realized that it was not an alien base, it was not a time traveling research place. It was used to produce like Cold War type of machinery. A lot of speculation about what Area 51 actually contained kind of subsided. So conspiracy theories sometimes do exist. When it comes to investment arbitration, there are a number of instances of hypocrisy, not only there, but also in other courts that I had fun, I poked fun at. Think about the UCOS arbitration, right? It's a very famous case. Russia decides to challenge the award in the Dutch courts, saying, among other things, that the award had been mostly written by the arbitral secretary, the tribunal secretary. So the arbitrators had improperly delegated their authority to a non-appointed fourth arbitrator. Right? Now, in the book, I do say it's interesting that the very lawyers involved in these annulment proceedings are all themselves very well respected figures in the arbitration field who are known for using our tribunal secretaries themselves. So there is sometimes this double standard, right, of what the practice is inside and how it is presented to the law. Is revealing that destroying the legitimacy of the system? Probably not. It's just creating a more transparent. Transparency is a very complicated word, assuming in a setting like this, but it retextualizes in a way that maybe dispels some also false myths about international. I don't know if that helps or I don't think anyway. Let's avoid self-aggrandizement. This is a book that very few people will read, and so I don't think that whatever I write will have any systemic impact.
Thank you so much for the talk. I have two questions. One, picking up on something you mentioned already, that, for instance, the Inter-American Court interviews were very open, ICJ were very cagey. I was wondering also, given that a lot has been made of epistemic communities and all that, so like, did you see other interesting, more similarities or more differences between like institutional cultures, shall we say, between the different courts? And the other one is just sort of, I'll just ask, what was the most surprising thing you learned throughout all this, given that you already had like significant practical, like practicing lawyer experience as well?
Thank you. The most surprising thing that I learned is how similar these various subcommunities were when it came to the objects of interest of their practice. So no matter where I looked, you had certain social dynamics whereby, for example, the assistants to the judges always refer to their judges as my judges, saying, well, and my judges, not always as in the judges who are my bosses, but the judges that I somehow like direct, my judges almost as my children. It was like I often found that language in various communities, and that didn't vary across the board. Of course, then the specific settings of each court and tribunal changed. So at the ICJ, you have clerks who are tied on a one-to-one relationship with the judge, and I think that was making them cagey. If their judge knows that they have been speaking to external sources, well, they might bear different consequences than a bureaucrat, say, at the ECHR, say, the registry, or the WPO secretariat, part of a team that is not individually tied to specific judges. So what surprised me, how similar certain things, how similar, for example, it was that practitioner academics leveraged their academic credentials also to have a specific impact on the evolution of the doctrines of the system, so that in a number of instances, so as a very famous example in investment arbitration, you have the old articles, the doctrine of arbitration without privity that was developed as a scholarly concept. Well, that's also a scholarly concept that has enabled the thriving of investment arbitration starting from 2000. But you also have it in other less suspicious settings. For example, the pilot judgment procedure in the European Court of Human Rights. I don't know how you're familiar with that. It's interesting. It's introduced at some point in history, but then if you look at the immediate, like in the year prior, you see a lot of academic articles written by academics who are also deeply involved in the practice of the court, calling for something like that and making proposals for these doctrine to be elaborated. So there's always this double level engagement when it comes to certain portions of academia who has very strong ties to it. So what surprised me was the similarities in those respects. These type of dynamics recurred across courts. There were, of course, significant differences, especially in the style of reasoning that people had in terms of thinking about the law. So, in terms of the audiences they thought they were speaking to. So, when I spoke to the Inter-American Court people, they said, well, what we have in mind as the audience is not necessarily the respondent state, is more activists across the continent who can use the judgment as basis for further kind of mobilization. We're thinking about the continental intelligentsia who will then spread the word. I'm not sure that this particular Latin American country will comply with the decision, but we're not working with that in mind. We're working with this community that will use this decision for good people will use this for good purposes, right? So that is one of the audiences. At the WTO, I remember, so internally, a lot of the questions about the audience were, well, will these counsel think about it? It was not what will the United States or China or Australia think about this decision. It's like, can you imagine lawyer such and such the next time he speaks, like, we'll go through hell. So there was a very niche, very tight community of people who had all known each other for a long time. And sometimes the immediate audience was the immediate circle of people around the court, even more so than the parties that they represent. So different audiences, sometimes narrower, sometimes broader. So these, in turn, do shape the culture of difference, depending on who you believe you're working for. Well, that changes the way you approach things, the way you communicate about things.
We maybe have time for one or two very short questions. I wanted to ask, what was your PhD viva like? So how does a PhD examiner engage with this, right? Because it's one thing to write something like this, to bend the genre, to put it out there for people to read, international lawyer or not, layperson, whatever. If you're an examiner of a book like this, how do you engage with it to, award a degree where you have regulations and the rest of it? What was that like?
It was a very long viva. It went on for almost 3 hours. Fortunately, I kind of took advantage, and I think my thesis supervisor at the Graduate Institute knew how also the composition of juries were. So at the Graduate Institute, you have one main supervisor, and then you have a second reader who is also from the institute, and he appointed someone who he thought would be kind of receptive to this type of efforts. And then, of course, there is the dreaded external member. One of the advantages of the viva at the Graduate Institute is that they give you written comments in advance. You're not surprised. You don't have, you can still have curveballs thrown at you during the viva, but at least you know from the written report on your work what the readers think. I was eagerly awaiting these written reports, and then the first comes in not from the external speaker, and says, I have a fundamental disagreement with this entire work. That was the first sentence in the report. I was like, basically the criticism, and I think it's a criticism that might resonate with on this side of the room, was, who is this book even for? So international legal practitioners will not be there. You won't change their mind. International legal academics, especially with a more critical bent, already know this. Again, there's a phenomenology here that you're trying to evoke. Thank you. It's like, now you're talking about the inner workings of international. Of course, maybe we wouldn't know all the details, but we know the gist of your argument. Does this make your book novel or with an argument? Probably not. You're simply telling a certain audience exactly what they already suspect, and they want to be. So this was the first report. And I was like, then of course at the viva, this discussion evolved, and I think that that examiner got persuaded that at least the work was worth pursuing. So the viva went very well, but it was not an easy discussion. Then the external examiner said, well, I think this would be very fun to publish, but once again, where's the theory, where's the argument? So what happened between the dissertation and the book is that basically we wrote the whole thing. So it's I still have the copy compare version of the two, just as a memento, and it's basically all red. I think there's a few black words that remain the same, but most of it has been rewritten. And then, of course, as usually happens at vivas, the supervisor then at the end intervenes at the end, tries to kind of save you from the slaughter. Anyway, but yeah, so that's how the viva went.
Well, I hope you found today's questions and this experience a bit more enjoyable than the viva. Let me thank all of you for coming and for your questions, and please join me in thanking for what was a really super interesting talk.